In today's video, I want to give you an important update on a major case out of Oregon that could have a huge impact on the Second Amendment. This case challenges the statewide ban on magazines that hold more than 10 rounds, as well as the mandatory permit system the state put in place. Both of these restrictions are part of what's known as Oregon Measure 114, and this lawsuit could determine whether those provisions stand or fall. Let's break down exactly what's going on. Measure 114 created two major restrictions. First, it established a statewide permit-to-purchase requirement. That means anyone wanting to buy a firearm in Oregon would first need to go through a state-issued permit process before making their purchase. Second, it imposed a ban on magazines holding more than 10 rounds. The law prohibited the sale, transfer, and even possession of such magazines after its effective date. Now, this measure was immediately challenged in court, leading to the case we're discussing today, Arnold v. Kotch. In that case, a state court judge, Judge Robert Raschio, issued a ruling striking down Measure 114 in its entirety. He found the law unconstitutional under the Oregon State Constitution and issued a permanent injunction to block its enforcement. Of course, the state of Oregon wasn't happy with that outcome. They quickly appealed, trying to get that permanent injunction lifted so the law could go into effect. The case then went up to the Oregon Court of Appeals. In a surprising move, the Court of Appeals issued a unanimous order siding with the state, essentially upholding both the magazine ban and the permit-to-purchase process. But here's the key part. The fight isn't over yet. Recently, the Oregon Supreme Court agreed to review the case and scheduled oral arguments for November 11th. That means in just a couple of months, this crucial lawsuit will be argued before the highest court in the state, and the outcome could determine the future of Measure 114 once and for all. Since this case is being argued under the Oregon State Constitution, it follows a different standard than federal Second Amendment cases. Specifically, Oregon courts apply a two-phase test when evaluating whether a firearm-related law violates Article 1, Section 27 of the state constitution. In the first phase, the court must determine whether Article 1, Section 27 even applies to the issue at hand. Oregon's lawyers have argued that magazines are not arms under the Constitution, and therefore, they claim these restrictions do not fall under constitutional protection at all. The second phase of Oregon's constitutional test focuses on balancing public interest against individual rights. Essentially, the court asks whether the law's stated purpose truly serves the public good, and whether that benefit outweighs the burden placed on citizens' constitutional rights. Oregon argued that Measure 114 was in the public's best interest because it would help reduce crime. But at trial, Judge Robert Raschio reviewed expert testimony and data, and he concluded that the state's claims were exaggerated. The evidence simply did not support the argument that Measure 114 would meaningfully prevent crime or improve public safety. Because of that, he found that the supposed benefits did not outweigh the constitutional violations created by the measure. However, the Oregon Court of Appeals later disagreed. In its decision, the court stated that the key question was whether the people of Oregon had enacted what they considered a reasonable regulation to promote public safety, even if it placed some limits on constitutionally protected arms. The appeals court took the view that as long as a law was constitutional in some of its applications, it could stand. On the permit-to-purchase issue, the Court of Appeals upheld the requirement, reasoning that the permit program and the background check system represented a modern legislative response to real public safety risks. They claimed that untrained or dangerous individuals obtaining firearms increased the risk of death or serious injury, and therefore, the permit process was constitutional. When it came to the magazine ban, the appeals court made a similar argument. They described the ban as a legislative response to technological advancements in firearms and magazines, which they said created observable public safety threats. Based on this reasoning, they upheld the magazine ban as well. But this wasn't the end of the story. The plaintiffs, led by Arnold, appealed further. In their opening brief before the Oregon Supreme Court, they argued that the Court of Appeals had applied the wrong standard. Instead of relying on historical tradition and prior case law, the appeals court had created a subjective reasonableness test with no objective criteria. The plaintiffs pointed out that under consistent case law, any restriction on arms must have a historical analog dating back to at least 1859, when the Oregon Constitution was adopted. Since no such historical laws existed banning magazines or requiring permits to purchase, they argued that Measure 114 could not be upheld. They also emphasized that even the Court of Appeals acknowledged that magazines are constitutionally protected arms. Under that recognition, the court should have struck down the law instead of creating a new test that departs from precedent. Because of these issues, the Oregon Supreme Court has now agreed to hear the case. Oral arguments are scheduled for November 11th, and the court will decide whether the magazine ban and permit-to-purchase system violate the Oregon Constitution or whether they can stand as legitimate regulations. It's worth noting that the Oregon Supreme Court does lean to the left politically. That being said, this case sets up a major showdown over both the state's magazine ban and the permit-to-purchase system, all wrapped into one challenge. No matter how the state court rules, there's a strong chance this case could eventually make its way to the United States Supreme Court. The best-case scenario for gun owners would be for the Oregon Supreme Court to strike down Measure 114 as unconstitutional. That outcome would force the state of Oregon to seek review from the U.S. Supreme Court, potentially bringing these issues into the national spotlight. However, that may be an uphill battle given the current leanings of the Oregon court. One important detail here is that throughout the course of this litigation, the Oregon Supreme Court has repeatedly declined to step in early on Measure 114. Multiple times, the state tried to pull the court in at earlier stages, but each time the justices refused. That could be a sign that they aren't fully convinced by the state's arguments, or at the very least, that they prefer to let the case run its full course before weighing in. Now, with oral arguments scheduled for November 11th at 9:00 a.m., we'll finally get a closer look at where the justices stand. The questions they ask, the tone of their hypotheticals, and the way they frame the legal issues will give us an early glimpse into their thinking. Once those arguments are heard, we'll have a much clearer sense of whether the Oregon Supreme Court is likely to uphold or strike down this measure. So that's the current status of this critical case surrounding Oregon's magazine ban and permit-to-purchase requirement. As this case continues to develop, I'll keep you updated with the latest information. If you found this breakdown helpful and want to support the channel, one of the best ways to do that is to subscribe so you don't miss future updates. And as always, thank you so much for your continued support.